the draft Silicon Valley Bank UK Limited Compensation Scheme Order 2024.
I call the Minister to move the motion.
Yeah.
Mrs Harris, it's a pleasure to serve under your chairmanship. I beg to move that this House considers the Silicon Valley Bank UK Limited Compensation Scheme Order 2024, which relates to the 2023 resolution of Silicon Valley Bank UK. This order confirms that the former shareholder of SVB UK, which was the Silicon Valley Bank US parent entity, is not entitled to compensation following the transfer of the bank's shares to HSBC UK Bank plc. This order has already been approved in the other place in the House of Lords. In early March 2023, SVB UK experienced severe financial distress resulting in rapid deposit outflows. This crisis, originating from its US parent entity, quickly spread to its UK subsidiary. By Friday the 10th of March, the Bank of England, acting as the resolution authority, declared its intention to place SVB UK into a bank insolvency procedure, absent any meaningful new information. Over the subsequent weekend, a private sector purchaser was identified. On Monday the 13th of March, the Bank of England exercised its power under the Banking Act 2009 to transfer the shares of SVB UK to HSBC UK Bank plc. This action was taken following consultation with the Prudential Regulation Authority, the Financial Conduct Authority and HM Treasury, and the Bank of England, reaching the judgment that the resolution conditions set out in the Banking Act had been met. The Banking Act requires HM Treasury to make a compensation scheme order when the private sector purchaser power is exercised. This order is a mechanism to establish in law what compensation, if any, is due to former shareholders of the resolved firm. The Bank of England undertook a provisional valuation when placing SVB UK into resolution. That valuation found that SVB UK shareholder would not have made any recoveries had the firm been placed into a bank insolvency procedure. The shares had no value at the point the firm was transferred, and therefore no compensation is due to SVB UK's former shareholder. The Bank of England then commissioned an independent valuation of SVB UK, which confirmed that no compensation is due to the previous shareholder of SVB UK. So, the order before us today confirms in law the findings of these valuations, that the former shareholder of SVB UK is not due any compensation. I would like to thank all the staff of the PRA and the Bank of England's Resolution Directorate for the swift and effective action that they took regarding SVB UK, and indeed officials and ministers at HM Treasury at the time. They worked tirelessly over the course of that weekend to deliver a solution that protected financial stability and achieved the objectives of the special resolution regime. The resolution of SVB UK shows that the UK's resolution regime works well, and the importance of the UK having the necessary tools to handle bank failures effectively. The transfer of the firm to HSBC UK was a good result for SVB UK's customers, who retained access to their money and the banking services they relied on, for taxpayers, with the firm being stabilised without any use of taxpayer support, and indeed for the UK economy, with the UK's vibrant technology and innovation sector protected from severe disruption. Mrs Harris, the compensation scheme order for SVB UK is a necessary step to formalise and conclude the resolution process, and confirm that no compensation is due to the former shareholder. This decision is based on thorough valuations and adheres to the legal framework established by the Banking Act 2009. I thank you very much for your attention and welcome any questions from shadow ministers or honourable members that they may have regarding this matter.
The question is, the committee has considered the draft Silicon Valley Bank UK Limited Compensation Scheme Order 2024. Shadow Minister Mark Garnier.
Well, thank you very much, Mrs Harris, and it is a great pleasure to be standing opposite, albeit in opposition, to the newly promoted Minister, City Minister. I look forward to spending an entire week locking horns with her. On this whole issue, first of all, can I just start off by saying that it is fantastic that we've had some very swift action. It just goes to show how the 2009 Banking Act has worked extraordinarily well, and how efficiently the previous government was doing, Mrs. Harris, when it came to resolving this financial problem. There was a huge amount of work done by a number of people in the previous government, on the Treasury Select Committee, looking at the Financial Services and Markets Act 2012, on the Parliamentary Commission for Banking Standards, doing the 2014 Banking Act. So a huge amount has gone on, and it is incredibly reassuring to see that when something does go wrong, the system actually cuts in incredibly quickly and resolves this very well. The Minister and I are going to be talking about bank resolution on Wednesday, and I think it's incredibly important that we make sure that we are working together on this, and I think we're probably in broad agreement. But as I say, we will be talking about it more directly then. Look, I think this does raise, though, an incredibly important point, and that is the point about shareholders. Shareholders ultimately are the people who take the ultimate risk in any sort of business. They're the bottom of the list of people who are compensated in the event of a winding up of any institution which is privately owned. And that is the right thing. At the end of the day, ultimately, private shareholders need to take that risk. But I think we do need to remember that those shareholders are taking the ultimate risk in any business, and sometimes we beat them up in this place because we don't necessarily like to see them make too much money. Part of that risk-reward ratio of the system that we have at the moment is that shareholders are taking a lot of risk, and therefore we shouldn't attack them for taking good returns, given the fact that they can lose every penny of their money. And I think the other point about shareholders, and in this case it was a single shareholder, but I think the other point about shareholders is they provide an incredibly useful service in terms of the governance of any institution to make sure that actually something like this shouldn't happen. As I say, it was a single shareholder in this case, but multiple shareholders do provide good scrutiny. So I think the tone about how we address shareholders is something we need to address. But look, this is absolutely the right thing. On this side, we recognise that this is the system working extraordinarily well, and I think certainly we're not going to oppose this, and it is very good that we're finally delivering the last part of this resolution. So I have no more to add, Mrs. Harris. Thank you very much.
Kate Malthouse.
Thank you, Madam Chair. I have no wish to detain the committee particularly, but I do have some questions about this particular process, not least because, as I understand it, was the first time that the Bank of England had used its resolution powers as they currently stand. I do think it has, what happened has wider implications that we need to think about for the health of financial services in the City of London. Now, the first of my questions is this. Could the Minister just confirm that there is no litigation outstanding either in the UK or contemplated either in the UK or the United States which this measure is seeking to obviate? And if that's the case, could you just elaborate a little more on what she knows about the decision-making of the Bank of England during this process? Because while she outlined at a very high level what happened, she didn't fill in all the detail. So, for example, as I understand it, Silicon Valley Bank UK Limited, the subsidiary, was a perfectly solvent banking entity within the UK. It applied for 1.8 billion of liquidity funding to the Bank of England when its parent was getting into trouble. A decision was made by the bank at that point to deny funding to that bank. Has there been any review about that decision? Is the Treasury aware of why the decision was, why the funding was not made available? What assessment was made by the bank? And in future, if other banks apply for similar liquidity funding when overseas parents are in distress, what criteria will be applied so that everybody knows exactly what they're doing? The bank then initially made a decision to put the bank into an insolvency procedure. It didn't immediately go for resolution. And in that insolvency procedure, obviously depositors were due to get their £85,000 as guaranteed, or £170,000 for joint accounts, but something changed over the weekend. And by the Monday, the bank had changed its tune and was going for what has now resulted, which is the sale to HSBC for nothing. Do we know why they made that initial decision? My guess is they changed their minds because the depositors went nuts. There were lots and lots of tech startups who had large deposits with the bank. Much of it had been money raised from shareholders. There was obviously quite a lot of political intervention. But what were the influences on the bank's decision-making? And if it changed its mind because the Treasury or indeed the PRA or the FCA said it should change its mind, why was its initial decision therefore deficient? And what does that say about the Bank of England's decision making? And then finally, I wondered, given that this was the first time that these powers have been used, whether there has been a review by the Treasury, as you would expect in such a, I guess, a kind of petri dish experiment situation with such a valuable industry, as to whether what happened was overall beneficial both to the UK economy and to financial services. I mean, she will understand that, you know, financial services is extremely valuable to this country, and anything that creates a sense of instability will be a detractor to the attraction of the UK for financial services. And the structure of Silicon Valley Bank, specifically that it had a subsidiary in the UK rather than a branch, was meant to promote that sense of stability and independence of regulation that would, in theory, have allowed it to trade independently. So all of these questions, I think, need to be asked, and I'd be very grateful if there hasn't been a review, if, given that she's new to the job, the Minister might acquaint herself with the issues in a little more detail and satisfy herself that this is not a negative for overseas banks establishing branches here, because I can't see myself since then, having had a look, and I may have missed it, that any overseas bank has done so. If they haven't, is this why?
Minister Emma Reynolds.
Thank you very much, Mrs Harris. Thank the Shadow Minister for his kind words. We're spending a lot of time together this week, so thank him for what he said about shareholders and indeed the principle of risk and return, and you know that we know that the more the risk you take, you know there's a correlation there between the return that you are due, but doesn't always work out, and you know we know that proportionate regulation encourages considered risk taking, and we're in favour of that. We want to see entrepreneurship in our economy. So maybe it's a more philosophical debate we could have, but I agree with a lot of what he said about shareholders providing scrutiny, and we certainly shouldn't criticise them for being shareholders. We need good shareholders in the economy, for the functioning of our economy. I'll turn to the Honourable Member for North West Hampshire's remarks, and I will attempt to answer all of his questions if I can. Obviously, I wasn't in the Treasury that weekend. One of his other colleagues was, so if he wants a very detailed description of those events, he probably should speak to the Shadow Business Secretary, would be my first recommendation. Secondly, there is certainly no litigation in this case. It is for the Bank of England as the independent regulator to weigh and balance the different trade-offs involved in this sort of decision-making. And I can't speak for the Bank of England, but I would point out to him that only 14% of deposits would have been covered by the Financial Services Compensation Scheme. So if he thinks that would have been a better eventuality, I think I will give way.
That's not what I'm implying at all. And as I say, I think resolution in this instance was the right thing to do. What I'm saying is that the Bank of England's first decision on the Friday was to go for an insolvency and only pay out 14% of the deposits. And it was only after pressure was brought to bear on a supposedly independent bank over the weekend that the strategy was changed to a resolution and the bank was transferred to HSBC. In fact, the Bank of England issued a press release to the effect that they were putting the bank into the insolvency procedure, as I say, and then over the weekend changed their minds. So what I'm asking is about the, I guess, the integrity of the Bank of England's decision-making, the quality and integrity of the Bank of England's decision-making procedure, given that they were initially proposing to do exactly what she's saying shouldn't have happened.
Well, I can't speak for the independent Bank of England, so I suppose I would gently suggest to him that if he has questions about the timing of the issuing of a press release on the Friday in March 2023, that he should, you know, if he has real concerns about that, he should convey those to the Bank of England. I will take up his recommendation to look into the issue more closely. But what I will gently say to him is that overall, I think we had a good outcome. And that was due to the work of officials in the PRA, the Bank of England, and indeed the Treasury, because by Monday morning, before the markets opened, we had a transfer from SVB UK smoothly into HSBC. And my point is that in the end, we got to a position where depositors were in a much better position on the Monday morning than they had been on the Friday. Regardless of the choreography, I think in the end we got to the right outcome. I think there has been a consideration, not necessarily of the timing of what he's talking about, but of the resolution process. And indeed, myself and the Shadow Minister and any honourable member here present will be debating the second reading of the Banking Resolution Recapitalisation Bill, which has already been through the Lords on Wednesday, which seeks to ensure that in cases such as this, and what was indeed good about this case was that SVB UK was in a relatively good economic position, but you could envisage a situation where that wasn't the case. And what we need to ensure is that we are protecting taxpayers, and we're going to be discussing those issues on Wednesday. But I beg to move that this order be laid. Mrs. Harris.
The question is that the committee has considered the draft Silicon Valley Bank UK Limited Compensation Scheme Order 2024. As many of their opinions say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. Order.